my name's Steve Schulman. I'm a partner at law firm Bora Goldstein, Altshuler, Nays, and Boydell. We're down in Tribeca. We're about 50 lawyers. We are a full-service real estate firm specializing primarily in litigation, with the exception of personal injury, property damage. So we're more into evictions, disputes between landlords, easements. We're in Supreme Court, bankruptcy court, to the extent that we deal with the issues that make up this seminar. We deal with all the regulatory agencies, whether it's the ECB, whether it's the Department of Buildings, HPD, in administrative hearings, in housing court, in Supreme Court, and there are a myriad of places where this gas leak can seep out into the court system. As I'm sure many of you who own multifamily residential property, multifamily properties know. I'm sure that it's the one area that I think can cause the greatest amount of anxiety, because it's really the one area that landlords can really exercise the least amount of control over. You can control repairs, you can control your boiler, you can get gas, but when it comes to control oil, but when it comes to gas, you have a gas leak, it's something that you didn't know where it came from, and all of a sudden you have a serious problem. You could have an injury, you could have a shut-off by Con Ed. So understanding what your responsibilities and obligations are, and understanding what the consequences of something that is a result of negligence or an omission, or something that wasn't your fault, I think are important to discuss. It's not very complicated. It can be rather brief. As a general outlook, regardless of what your lease says, and this applies to residential, but regardless of what your lease says with regard to who's responsible for maintenance of repairs, who's responsible for conditions in the apartment, the real property law imposes upon a landlord an obligation to warrant that an apartment is safe. Life and safety, property damage, but primarily essential services must be provided. That includes heat, that includes working water, that includes things in your apartment that won't pose either a latent problem or an obvious problem, whether it's your windows. So the whole gamut is not just the city, but the state of New York imposes that, and that obligation is imposed upon all residential properties, be 1 family, 2 family, 3 family, 50 family, and that's very important to understand, because the seminal case that operates within the court system that really hasn't changed, and it's used as the framework upon which most of these decisions are made by these courts, is Park West versus Mitchell. It's a decision that came down from the Court of Appeals in 1979. And ostensibly what it was a citywide sanitation strike. And it was a number of tenants whose garbage wasn't being picked up. The landlord would bring it out to the street, wasn't being picked up, and it smelled, and there were all sorts of ancillary problems that tenants had. And the tenants sued for a rent abatement, and the landlord's position was, not my fault. Now that's similar to the situation you'd have here, where it's Con Ed, it's not my fault. They backhoed into the main street, they cut the line, it's not my fault. The Court of Appeals says doesn't matter. You warrant the habitability. So whether or not the negligence comes from someone else, whether it comes from the tenant, whether it comes from the city, it doesn't relieve you from your obligation to warrant. So what does that mean? It means that the court can impose upon you a liability in the form of a rent reduction. Now, if you deal with regulatory apartments, you know that often happens in the DHCR. A tenant files a reduction in services complaint, and it's not my fault, the tenant caused it. Well, this DHCR says, well, we're sending an inspector and we're freezing your rent, and we're rolling it back, and this, that, and the other thing. So you may have a claim against the tenant, a holdover proceeding, an eviction. You may have money damages you want to bring because they caused this, but ultimately that responsibility rests upon you. And it's very important to understand that, because you don't want to get distracted from, it's not my fault. You want to deal with, well, what are the consequences? So you have, to me, there's two primary sources for gas, and I'm talking about gas leaks. I'm not talking about gas heat right now, but there's two primary sources. One is it's a building-wide problem. It's happened out on the street. You have a luxury building. There's 350 units. There's 25 floors, and the gas is shut down. The other situation is where it's in one particular apartment, either because the apartment is old or because the tenant did something in the apartment or was negligent. Those are two situations that you would come across. In both situations, there is the imposition or the potential imposition of liability to you in terms of rent. And what could that be? Now, gas is considered an essential, just as heat and just as hot water is, so is gas. So there's a much stricter standard. There's much less wiggle room in terms of your liability. So now the question is before we talk about where this can happen, what could happen? Well, the courts have ruled that upwards of 20 to 30% of a tenant's rent can be deducted for those months or those days or those weeks in which the tenant doesn't have these essential services. So it could be, if it's gas heat, it could be lack of heat. If it's a gas leak, then it's because you can't use your gas stove and your oven. And it becomes factually based on what exactly was the impact. Now for heat, heat can actually sometimes be less than cooking gas. Primarily, if you have a 3-bedroom apartment and you can't sleep in one apartment, you could sleep in the living room, you could sleep in the other bedrooms, then if you look at the whole structure of the apartment and you designate what percentage of the apartment couldn't be used, it may be actually smaller than what percentage of the apartment couldn't be used if you couldn't really use your kitchen, if you couldn't cook. So sometimes the courts have really gone out of their way to impose upwards of 30% abatements for these situations, and on top of that, for lack of gas cooking, and on top of that, to reimburse tenants for meals. It also depends on what the landlord does to mitigate those damages. Now, there are some obvious things that were mentioned, such as a hot plate. Less obvious could be a microwave oven. Things that give the tenant the ability to utilize something alternatively while this situation is going on. There's two reasons for it. One of them obviously is the potential liability, the dollar damage, but the other one, which is to me more important, is to stay out of court. There are some tenants that are not hysterical. There are buildings where people are reasonable, where either they don't have time because they work, or because they like their landlord, or because they're in a deregulated apartment and they're afraid they're going to get, their lease isn't going to get renewed, all kinds of stuff like that. And that's the reality. And they may not want to go file a 311 complaint. They might not want to start a proceeding. They may not want to sue the landlord. They don't want to agitate the situation where they know it may not be the landlord's fault because they see the hole in the middle of the street and they know that it's not. So providing these kinds of mitigating devices can help maintain that relationship. Now I had it turns out it was my son's girlfriend who lived in the East 20, Gramercy Park, that area, and the building, and it was a beautiful building, and it was the gas was shut down for I think half the building, and it went on during the summer, and it went on for almost 8 weeks, and I was absolutely amazed because there were no violations for gas placed. No one made a complaint. There was no pending HP action, and I even contacted the landlord for the benefit, just to talk and find out what was going on. I spoke to the property manager. We're working on it. And I was absolutely amazed because whatever they did kept these people out of court. Now, there were signs saying the gas will be shut down. There was some oral communication saying, just give us your slips and we'll reimburse you. So that's a very important practical aspect of dealing with this kind of circumstance. As far as where can this happen? Well, there really are 4 areas where you're faced with this type of problem. The first area is in civil court or small claims court. where the tenant pays their rent, the tenant doesn't file an HP action, but sues you in civil court or small claims court and has receipts. Yeah, you have to deal with that. You have to get a lawyer, or you have to go down and settle it yourself, and you have to, it becomes a factual issue. Ultimately, the court's going to find that you're responsible to some extent. They're going to apportion an amount of damages, and so it really is a case-by-case situation. The second situation is where a tenant withholds their rent and interposes a defense or a counterclaim to a non-payment proceeding. That can be very aggravating, but those also can get settled, because hopefully by the time you get through, you get the rent demand out, you get the petition, you're in court, the situation has resolved itself, you work something out. By and large, I'm sure you've all had this experience where you've been there with 3 or 4 tenants where they're complaining about some kind of gas situation or heat, and then I only bring up heat because there could be gas heat. And where you work it out, you give them a month's rent abatement, you give them $30 or $20 a day towards cooking, something that just makes it go away. The city starts an action against you, or the tenant starts an action against you, an HP action. An action where they come down to court, they call the city inspector, a violation is placed, and you're a defendant. That can be very serious. The reason it can be serious is because the lack of these types of services constitutes an immediately hazardous condition, which would, on the level of A, B, and C, from the city's perspective, is a C violation. By statute, C violations, if they're emergency, have to be repaired in 24 hours. If they're not quote-unquote emergencies, it's 7 days. And you're in court. Now, what's your defense? You don't really have a defense, because the statute requires you to maintain services, the real property law requires you services. So what's your defense? Your defense is, listen, it's Con Ed's fault. It's the tenant's fault. The tenant illegally altered the apartment and put in a faulty gas dryer or something else. The bottom line is that the only ally that you'll have is the city. Because the city isn't going to be hysterical. The city is going to be reasonable. The city is going to understand the time frame. The city isn't going to want to be bothered with dealing with a hysterical tenant coming in complaining that I don't have heat or I don't have gas and I need it tomorrow. And the judge will be, hopefully, it's been my experience, somewhat sympathetic to the reality of the fact that this will take 4 or 6 or 8 weeks, and we'll try and muster some kind of consensus amongst the parties so that at least the landlord is providing a hot plate, or the landlord is providing reimbursement if, for example, you have gas heat, and you have gas running your hot water heater, to go to the local health club, go to the local Y to take a shower. So the idea is to try and come in with a plan. This is what happened, this is where I am, this is where I'm going, and not just to stand there and say it's not my fault. I don't recommend responding to these things without a lawyer, especially when it comes to gas, because gas itself can be something that can take a very long period of time. But again, the liability imposed upon you can be the cost of not doing the work within the statutory time frame, which is 7 days, and the possibility of civil penalties. So these things need to be addressed, almost to a point where you need to sort of kind of give in and say, look, we're going to work together and we're going to resolve this, as opposed to fighting. One other aspect which came up, which I was thinking, is what can you do to sort of prevent this situation? I would imagine the fear of most landlords when they read the Post and they see a fire, or they see a death, or they see an explosion, is what do I do? How can I prevent this from happening in my building? Well, to me, the most immediate thing is make sure that there is nobody in your building who's living in an illegal apartment. There was just an article in one of the newspapers about a death of 2 children who were playing. They started a fire in a basement. And I think it was in Ridgewood. And my first thought was, as I'm reading the article, is that they were in the bedroom in the basement of the house. Now, you know, there are clear laws under the multiple dwelling law as to who can occupy, and certainly the basement is not, unless it has enough light and air, unless, you know, you're in compliance with the C of O. So the first order of business is to get rid of your tenants who are in these apartments that are illegal. You have, so A, to be proactive to prevent the possibility of this, but also in order for you to be in a better condition with your insurance company if there is an injury. So you've done what there's nothing going on that you knew about and should have done something. The other thing is, again, mentioned it before, is illegal alterations. The tenants have a responsibility to provide access. Going back to the HP case, one of the defenses you might have, or sympathies you might get from the court, if the tenant caused the condition, or if the lines need to be inspected and you can't get access, is the fact the tenant's not providing access. What will the court do to you if you tell them that the tenant's not providing access? They'll say join them in the proceeding or start a holdover proceeding, bring an eviction proceeding. So that access can actually be a very, very little nugget of positive for you in order for you to keep the city off your back. So you're looking for illegal washing machines, illegal dryers, you're looking for alterations, you're looking for caked over stoves, or maybe you're looking, I mean, it's not too difficult to find, but you're looking for these things, and then you're bringing some proceeding, you're sending some notice to them, putting them on notice that this has got to be removed. And it's better to be cautious about that as opposed to walking in and smelling gas. The last thing I can say, having to do with this, is elderly people. People who can create a problem, they leave the gas on. I mean, I'm sure that you know that it happens. They're either mentally ill or they're old and they're forgetful, and what do you do about that? APS has become, Adult Protective Services has become much more aggressive in investigating situations and not waiting for the courts to appoint. I've had situations, Collier's cases, where people have stored myriad belongings, which themselves could be fire hazards, where there's no case pending. We haven't started an eviction proceeding, and the client called APS, and APS has actually come in and got involved. I had one situation where APS contacted City Council, and the City Council sent somebody out and they cleaned it up. So in sum, the potential for liability is real, and in some cases can be significant if it's building wide or if it's long term. But other than the fact that there's something happening outside your building, there are things that you can do to help shore up your, or to minimize the potential liability from tenant-caused conduct. Thank you.
Howard, and Greg is going to introduce you. You can stay right where you are, but Greg's going to do a little introduction.
It is really my distinguished honor to introduce the president of the Realty Advisory Board on Labor Relations, someone who I spent, I think, the whole month of April with during these negotiations, and it's my honor and privilege to present to you the president of the RAB, Howard Rothschild.
So I think I spoke to this group about 5 or 6 weeks ago, and the first question on everyone's mind was the question that I couldn't answer then, but I can answer now. The question then was, will there be a strike? Actually, I gave an answer. I don't know. And I'm happy to report that no, there won't be a strike. Just, I guess, a quick review of where we were and where we're going. And actually, I also have a handout, which I can leave at the front desk, which is a summary of all of the changes in the terms of wages and benefits and language changes in the agreement. So we began this process back at the end of February, the RAB and the union. We've been doing this for 80 years, this little dance in April. And my wife had always asked me, why do you always go down to the end? Why don't you start earlier? And I said, dear, in the most patronizing way I could do it, but dear, it doesn't matter when you start, it's when you finish. So we started earlier, and guess what? We finished early. So as usual, she was right and I was wrong. We finished 9 days early, which is unprecedented in the 80 years of our negotiation with Local 32BJ. And I think there were a lot of people that were quite concerned at the outset. The market change in the political landscape and the economic landscape. Remember 4 years ago, we had a different mayor, we had a different city council president, we had a different city council, and we had a completely different economy. The stock market was just falling through the floor. We were in the midst of the Great Recession, and it was a scary time. Contrast the political landscape, the economic landscape now, and not only the investment markets, but also the real estate markets in New York City. And so I think what I said back 5 or 6 weeks ago was that I had thought that the main issue in this contract would be wages. The last 2 contracts that we had with 32BJ leading up to this was the 2006 agreement, which did not give a big wage increase because there were large increases to the health fund, and the 2010 contract, which did not give large wage increases because there wasn't money for anything in 2010. And so we were faced with that and the fact that essentially for a long time, apartment building workers didn't get a very large wage increase. I'm happy to say that the terms and conditions of this new agreement provide for a wage increase that averages about 2.7% for wages only. The first year of the contract is a 3% increase. The next 2 years is about a 2.4% increase, and the last year is a 3% increase again. The total package for wages and benefits is about a 3.4% average over each year over the course of 4 years. The other highlight of this agreement, and I would urge you, if you don't use this, to consider using this, we got a new start rate. We used to have a start rate for newly hired employees who are porters or doormen of 80% of the standard rate for up to 30 months. We have a new start rate, and the new start rate is for new people. So if you have someone in the glide path of the 80%, they stay in that glide path. But for someone who you hire as of April 21st or after, they can get a minimal rate of 75% for the first 21 months, and then 85% for the next 21 months. Some buildings use this, some buildings don't. The ones that don't, I quite frankly don't understand why they don't, but they don't. This doesn't affect your summer vacation relief, which remain at a 60% rate. So you can continue to use that. The last thing I just wanted to note is that we made a huge change in the contract in 2010 that remains in this contract, which was the suspension of the maintenance and benefits provision of the agreement. The maintenance and benefits provision of the agreement essentially could allow the trustees of the fund to have carte blanche with any future benefit fund contributions. And that's what happened back, as some of you remember, in 2005, where there was a huge increase in the health insurance number because the maintenance and benefits provision allows the trustees, in their opinion, to change the contribution levels to maintain the benefits. So we suspended that in 2010. It remains suspended till this day. And we've capped the contributions in the out years of the contract. As you probably know, we have one set of funds for the entire industry, and we have contracts that sort of leapfrog over one another. So we just did the residential in 2014. We'll go back and do the commercial in January of 2016. And so it's really the commercial agreement that sets the rates in the residential agreement. So we have capped numbers in years 3 and 4 in this agreement, and that's very important. Where we are now, we finished the agreement, as you probably know, back on April, I think it was April 12th, 9 days early. So everyone, I guess, sort of had a happy holiday. I wasn't eating matzah in my hotel room, which was very enjoyable. And we had called an RAB board meeting for this past Monday, April 21st. And I'm happy to report that the agreement was ratified unanimously by our residential board, as well as our full board. And now we are awaiting the union's ratification. Their process takes a little longer. They send out paper ballots to all of their members. That takes some time to mail it out, get it back, count it, and that should all end on May 12th. So I'm fairly confident that they will ratify. In the past, I mean, historically, their ratification votes are more than 90% in favor. I mean, this was a very fair deal. Anyone who's been around me, and you're probably tired of hearing this, but like I said, we want to come to a fair and reasonable agreement, and I think we have.
Is the starter rate 30 months or 42 months?
So the old start rate was for 30 months, 80% for 30 months. The new one is 75% for the first 21 months, and then 85% for the next 21 months. So it's a total of 42 months. It's a way to save a lot of money. And these are very good jobs, and people tend to stay in these jobs. But every once in a while you get turnover. People leave, people get fired, people die. And if you figure that even a 5% turnover rate, if you can save, the 5% of 25%, that's 1.25%. So this agreement goes from, costing, let's say, 3.4% to maybe 2.2%. That's a drastic saving. Some buildings, you're going to have a small building, no one leaves. Other buildings, you're going to have a larger building, and you have a lot more churn. But the main thing is to use it. If you have people turning over and you don't use it, it's worth nothing. So, and I got to tell you, we fought very hard to get this in the agreement, and so you should try to use it if you can. Anything else? All right, well, I don't want to stand between you and lunch, especially after we heard all those stories about kitchens with gas leaks and people couldn't cook. I was getting hungry. So thank you very much.
Thank you, Howard. Thank you, very much. And one of the other ways we have turnover in our building is because the staff gets educated and they get another job, hopefully in our industry. And from what I understand, there's well over 200 brand new buildings coming online in Manhattan before the end of this year. So that sounds like a lot of work for all of us. And so we do want to encourage our staff, even if we want to keep our best doorman. I have something that, an old version on a Henny Youngman line, which is, take my best doorman, please. Because the only way you're going to really get your staff to buy in to watch over your building and to be proactive for things like gas leaks is to encourage them to improve themselves just as you do for yourself. So while you think we never want to lose our best doorman, the worst thing you can do is to try to clamp down on your best doorman, because you need the rest of the staff to see that you're encouraging them to progress. And then everyone buys into his success. Two announcements. We heard a lot about early detection for gas. Well, there's also early detection for other things that may be invading your building. And it could be mold, it could be bed bugs, and you've heard me talk about this before. Okay. This is a collection swab kit. It is not meant to replace a third-party tester to clear your building of mold or any other infestation. And so this is now part of your entire building's toolkit, which is we must know as soon as possible if something is growing, whether it's got 6 legs, 2 legs, or all sorts of scalloped edges around it. We want to know if it's growing in our building the minute we detect it. So this costs $150 to get that test result. And once you get that test result, then you make the decision if you're going to move forward. Bring in the bed bug smelling dog, or bring in the mold eradicator, whatever it is. Are you going to take down a 16-foot wall that's maybe 8 inches wide, this kind of thing. But for $150, you get information early so you can move faster. And every attorney will tell you that when you're in front of the judge, if the judge believes that you did not move fast enough and now you're sitting with this situation, it's far worse for you. Okay. The other situation is, one of our main sponsors for today is our back page advertiser, Flag Waterproofing, so I just want to thank him. And I want to announce we had to change the date of our golf outing. There turns out there were 2 industry golf outings on our regular scheduled first Monday in June. So we are now Monday, July 28th. And we've also changed the location, which is the Bergen Point Golf Course, which is in West Babylon. Very easy to get to, 1 mile from the Babylon train station. We can have an easy jitney. Anyone spending the weekend out in the Hamptons, you just take the train right in and we'll pick you up at the train station. What's nice about this location is one of the things we're going to be doing is we're going to be highlighting some of the projects that the town of Babylon and the county of Suffolk are doing with reference to transit hubs. And Wyandanch Rising at the Wyandanch train station, the town of Babylon awarded that contract to the Albanese organization, and at the end of this year, they're going to be starting to open it up. So it's going to be commercial and office and residential, and so this is going to be the first of many that we're going to start seeing on that Ronkonkoma line as well as on the Babylon line to develop and enhance these neighborhoods that have just not budged. And so it means 2 things. It means a lot of work for the vendors in this industry, and it means additional work for the property managers because now you can live in Babylon and you can work in Babylon in this job. So we're going to bring our golf outing and highlight some of this work. Our next meeting is going to be at Ronald McDonald House, and we're going to showcase the fine work that they've done in the last couple of years for energy savings. And what we know is about 6 years ago, we started having energy seminars, and then about 4 years ago, it really picked up. And so now we're seeing incredible returns from the buildings. And so we're going to film it, and we're going to learn about it, and then we're going to do the same thing in June at the Schwab House, who is having a wonderful rate of return, which Peter penciled those original documents and brought that online. And so then what we're going to do is the seminar during the day at the golf outing, we're going to bring all that information together, not just those 2 locations, but as much as we can, and you can learn about it there, or we're going to use it as a means to reach out to the people out on Long Island to learn what we've done here in the city. So that's our announcement there, and then our next meeting is in September, and our trade show is at the end of October. So with that, Alex, you had one thing you wanted to say about gas to close it down. So you've got 45 seconds.
45 seconds. So remember energy efficiency and what it has to do with natural gas. The buildings are tighter now to save energy, and small leaks from the gas pipe usually could vent out of the building easily. But now we make the buildings tighter, so any leak has significant effect on it can accumulate in a building. Okay, so one thing which I would advise that you check all your equipment, gas-fired equipment in a building. Make sure that it has a record of filing with the building department and testing. Okay, so this is very important. And also, after this meeting, you will go back to the building And if you smell gas, you call Con Edison or utility, right? But you know that natural gas, I believe it doesn't smell. It's special additive odorant in the gas which is added that we can smell the gas. This is it. So just make sure that you have a record, because it's very important when anything happens. It's very important that everything recorded. And sometimes you feel like, oh, if I move a stove or range, it's like just a little extension of 1 foot of pipe, and it doesn't affect, so I can do it. Or I install water heater, and we can do it without filing. Remember that gas piping requires special, some fittings are not allowed on a steel gas piping. So, and this only inspector can determine, you know, so it's very good, it's required to file with the building department before you do any alteration. And another thing is when you do reconnection, just replacement of equipment, you actually are not required to test your piping, gas piping, because you just make a connection. But remember, if you didn't have it, I just make a gas, like gas test for 5 years in your building. I would suggest that since you have a plumber on the job, test your piping, because most likely you would find a leak. So be safe. Thank you.
Thank you, Alex. Very good. Thank you. And thank you, Dave. Thank you, Peter. Thank you, Stephen. Thank you, Howard, very much. Thank you. Have a great summer. Thank you.
You're not going anywhere without No way! And it's your
You wanted you gotta say Margie.